Well, welcome back to Media Law. We're on to the second part of Module 1. And remember, this is just a mini lecture to accompany your deeper learning by reading the chapters and listening to the full lectures. This week we look at the material based around Chapter 2, which is to do with free expression and mindful practice in media law. There are several issues covered here. One of the most important is where we track the history in the textbook of press freedom as a notion. We look at press freedom from way back in the days of Socrates and follow that through some of the key philosophers of the 16th, 17th through 19th centuries. Milton, Locke, John Stuart Mill, who all spoke about principles like truth in society and why the free speaking of truths is so important to a democracy. I encourage you to read that background material very closely because it underpins many of the legal decisions that have been taken in modern times, because that ethos of free expression and then press freedom after the advent of the printing press is really a fundamental philosophical notion that is at some tension with other parts of society as they try to regulate expression and media behaviour. The textbook also talks about the international context of free expression. And it talks about the United Nations, various instruments at United Nations level that protect free expression. Although these are more aspirational documents because Australia, for example, unless it formally ratifies that into its law, it's not something that it has to follow to the letter. And either way, there are readings of that allow legislators and courts to navigate that so we don't actually have absolute free expression. And that's a very important point. Nowhere in the world is there absolute free expression. Free expression is what we call a continuum, and different countries have different levels of freedom of the media and free expression. If you look each year, for example, at the international agency Reporters Without Borders, based out of Paris, they release a list of close to 200 countries of the world and rank them according to their level of media freedom. Typically, the Northern European and Scandinavian countries come out near the top of that list. And sometimes it's surprising to find Australia or the United States down there in the high 20s, down to perhaps as low as 50 for some of these Western democracies. But they're a long way on that continuum from countries like China and North Korea that are way down near the bottom of that list of press freedom internationally because of the level of censorship they have of the media, social media and free expression in those countries. There's an important historical context in Australia to free expression. Of course, Australia inherited the laws of England when it was established as a colony, and England already had a relatively proud record of free speech and free expression through the likes of those philosophers that I just mentioned, who had pretty much pioneered that through Western philosophy and thinking. John Milton, Locke, and John Stuart Mill are the prime examples in the textbook. So there was an entrenched understanding of the need for a free media coming through court cases and through legislation from the earliest colonial days. However, the textbook does talk about some early colonial decisions where there were fighters for press freedom, there were editors, judges who had to fly the flag of press freedom in the early colonial times because there were governors and others who wanted to clamp down on the media and essentially establish a highly censored colonial regime. Now this has flowed through into the Australia of the 20th and 21st centuries, the ethos of media freedom. Now bear in mind, wherever governments have the opportunity to wind back media freedom in some way, they normally do. And while Australia internationally has a relatively high level of media freedom, it also has many, many laws that impinge upon media freedoms. And that's pretty much the topic of media law. That's the kind of thing we study in media law, these many and various impacts upon media freedom, what some might call gags or censorship of the media for often very good, very legitimate public reasons. We don't have unbridled media freedom or free expression. If we did, it would be a very different kind of society that we have. But it would be open to all sorts of abuses. We would have unshackled pornography on our Australian-based internet and social media feeds. There would be all sorts of abuse of people from public officials in the public domain. Now some might say we do get that. If you look at the comment stream on some Facebook posts, we get all sorts of bigotry and hatred. But some of these are actually actionable, as we'll learn later in the media law course. An important series of High Court decisions were handed down. Now you learned last week when you were looking at Chapter 3 about the legal system, you learned about Australia's High Court, how it's the highest court of appeal, and its decisions hold the most weight over legal other courts and sometimes over legislators and their behaviour. And this is what happened in the area of free expression. From 1992, some very important cases that are explained in the textbook. Most notably the ACTV case that's mentioned there, the Theophanous case, through to the Longy case. All of these are in the text and mentioned in detail. But they were court decisions related to different aspects of free expression as part of our constitutional democracy. And what the High Court did through these decisions was read into our Constitution an implied freedom to communicate on matters of politics and government. What the court said in a nutshell through these decisions, with some very, very strict limitations and exceptions, I must say, but what the court said was that although there is no formal right to free expression stated in writing in our Constitution, because we are a democracy and because of our particular system of democracy, it is implied or assumed that there should be some freedom to communicate, particularly when that communication relates to how our country is being run, the politicians and the politics of engaging in democratic debate. And that should mean that some otherwise offensive or actionable comments made by people, communications made by people in a democracy might be excused because of this implied freedom to communicate. Now, in the textbook, you'll see how that was firstly developed. It was shaped in some ways into what we might call a defamation defence, or a version of one of the defamation defences, which we look at in our module around defamation, the law around damaging people's reputations. and it's become known as the Longy defence, or the Longy version of political qualified privilege. We learn about that, but we also learn through the textbook about several exceptions to that, and how in many ways it's been read down by the High Court since 1992 in different fact situations. So it's very important to get your head around that implied freedom to communicate on matters of government and politics. This relates a little to another topic area of Chapter 2, where we look at different press systems throughout the world. And while Australia does have that erring on the side of free expression, many other countries do not. And the question becomes when we're theorising about free expression and the media's place in society, where Australia might sit. And the textbook mentions a very old piece of research, Siebert and his co-authors' 1963 work looking at the 4 theories of the press. Now, many others have looked at that since then, but importantly, amongst the 4 theories of the press that they identified, essentially different press systems in operation throughout the world, many have viewed Australia to be a libertarian press system, based very strongly around a US-UK approach to freedom of the press and the notion of the media as the so-called fourth estate, where one might publish and be damned of the consequences, and, you know, in the vein of the US First Amendment, which guarantees the free press. More recently, however, many others, particularly those looking at media ethics, have suggested modern Australian media might be better viewed, not in the sense of the libertarian model, but under a model called the social responsibility model, where ethics should actually drive our media behaviour, and we should be really thinking of the interests of many other stakeholders in our ethical determinations, and not just barging through as a publish and be damned fourth estate approach to media freedom. I'd be very interested in seeing your views about this tension between these different models. The final topic in Chapter 2 is to do with what we call mindful practice in media law. Now, mindfulness is in some ways a very trendy modern phenomenon. Its origins were in Buddhist ethics, actually, related to meditation. But there are many educationalists who have applied that in a professional context. And the one whose work I like the most is an educationalist called Donald Schoen, who wrote about the concept of reflection in action. And Schoen's thesis was that as professionals, whether we are journalists, public relations practitioners, or lawyers, as working practitioners, we must be mindful in action as we are encountered with a professional situation. We must be able to reflect in action upon the potential consequences of those actions for ourselves and for others. And it explains there that I believe this brings to our study of media law the notion of mindful practice, reflection in action, helps us to embed our learning, but also helps us become much more socially responsible in our decision making, and in fact can actually keep ourselves and others out of trouble. There'll be more on this as the course goes on, but the problems that you are confronted with in your problem-based learning encourage you to think mindfully and reflectively about the situation and about the legal ramifications of the situation for yourself as a protagonist and of others who, where your work might impact upon them. Finally, the final slide is a reminder of your study plan. A reminder that already you should be immersing yourself across all of the different aspects of this course and its learning activities. These mini lectures are a mere introduction in a conversational way. There is the full lecture that you can access that's been recorded. You need to be thinking of it in terms of both your thoroughly read chapter readings, this week chapter 2, and the questions that come at the end of those chapters, reflecting upon those, thinking of those in terms of your learning problem and the ramifications there, and engaging in the other learning activities so that you are really deepening your learning around the course. And please find some recent examples of any of these topic areas and tweet them to the hashtag #MLGriff so you can share them with me, your tutors, and other students. We'll see you next time.